The summer of 2025 began like many others in New York's legal districts: a stack of papers, a case number, and two people on opposite sides of a question that most people never think about until they're forced to. Curtis, 50 Cent Jackson's publishing company, G-Unit Books, filed suit against Shaniqua Tompkins, claiming she had violated a life rights agreement signed in 2007 in which she sold the exclusive rights to her life story for $80,000 and a percentage of future royalties. The specific trigger was mundane by internet standards: social media videos. Tompkins had posted tell-all Instagram videos discussing her relationship with 50 Cent, including details about the rapper's infamous 2000 shooting and his feud with Diddy. But nothing about this case was actually mundane. To understand what happened in those Manhattan courtrooms between March and September 2026, one needs to go backward, much further backward than the contract itself. The history between these two people preceded the lawsuit by decades. They were together during the 1990s and welcoming their son, Marquise Jackson, in 1996. This was before Get Rich or Die Tryin', before Inda Club, before anyone outside New York could spell his name. Tompkins was there in the early phase, the uncertain phase, when Curtis Jackson was still building toward becoming something. Then the world shifted. The pair would eventually split amid his rise to fame, with both parties acknowledging their tumultuous and oft-strained relationship on numerous occasions. What emerged after the split was not simply a custody dispute or financial settlement. 50 Cent would later criticize Tompkins in his 2020 self-help book, Hustle Harder, Hustle Smarter, accusing her of negatively influencing their son's supposed entitlement while criticizing her own work ethic. The public disputes were vicious and sustained. Parental alienation claims, and a relationship so damaged that the father and son had not spoken since a text altercation and hadn't seen each other face to face since May 2012. It was during this period of maximum acrimony that G-Unit Books entered the picture. The solution they proposed wasn't a settlement or mediation. It was contractual silence. It was during this period of maximum acrimony that G-Unit Books entered the picture. The solution they proposed wasn't a settlement or mediation. It was contractual silence. The agreement itself was written in language that would have seemed almost archaic a decade ago, but became increasingly common as the internet democratized storytelling. Tompkins sold the exclusive rights to her life story, including her name, likeness, personal experiences, and all related publicity uses, to G-Unit Books, with those rights described as unconditional, irrevocable, exclusive, and perpetual. The money changed hands, $80,000, which Tompkins claims she only received in the amount of $35,000 after the company deducted $5,000 to pay for a lawyer. She says she never hired. In nearly 18 years the agreement held. It wasn't because Tompkins accepted its terms as fair. It was perhaps because she recognized the machinery behind it. Tompkins said in a sworn affidavit that the deal was pushed on her during the collapse of her relationship with 50 Cent, when she was emotionally and financially dependent on him and under pressure from people in his circle. She was a stay-at-home mother who had abandoned a business venture at his insistence. The leverage was complete. Then, in the summer of 2025, she spoke. The videos she posted were collectively over 2 hours long and focused mostly on Tompkins' relationship with 50 Cent, discussing the rapper's 2000 shooting and his long-running feud with Combs. She didn't seek a negotiation. She simply told her story on her own terms, and G-Unit Books responded immediately with legal action, seeking $1 million. What followed in the courtroom, however, was not the swift victory Jackson's legal team had anticipated. Justice Robert R. Reed, the judge assigned to the case, faced a straightforward procedural question in March 2026. Had Tompkins been properly served with the lawsuit papers? This seems like a technical detail, almost administrative in nature. But in legal systems, procedure often determines outcome. Tompkins claimed she never lived at the addresses where Jackson's team tried to serve her, and she only learned about the lawsuit upon receiving calls from reporters. G-Unit Books had attempted what is known as a default judgment, a legal maneuver that awards victory to one party when the other fails to respond to a complaint. No trial, no testimony, No examination of evidence. Just a win. Reed denied it. The judge found that Tompkins had offered a legitimate reason for failing to respond and had defenses worth considering. This meant the case would move forward. Tompkins would have an opportunity to argue her position, and her position, when it came, challenged not just whether she breached the contract, but whether the contract itself had ever been valid at all. In her filings, Tompkins made allegations that transformed the case from a business dispute into something closer to a portrait of control and intimidation. She accused 50 Cent's late manager, Chris Lighty, of intimidation in the process of getting her to sign the agreement, with repeated phone calls insisting she had to sign. In a sworn affidavit, Tompkins recounted a 2005 incident involving the film Get Rich or Die Tryin', where a meeting at the New York headquarters of Violator Management allegedly turned into a physical assault when she refused to sign a contract correctly, during which she claimed she was grabbed by the hair, dragged across the office, pushed to the floor, and choked. 50 Cent's legal team responded not by engaging with these narratives, but by attempting to contain them. In a sworn filing, Jackson asked the court to restrict parts of the record, arguing that certain allegations from decades ago were wholly irrelevant and could cause unnecessary harm, stating that Tompkins seeks to inject inflammatory and defamatory allegations concerning me personally into this litigation. The strategy was clear: acknowledge the contract, dismiss the context, focus only on the question of whether its terms were breached. This is where the case became philosophically interesting, if not legally clear-cut. 50 Cent's argument essentially held that contracts don't require consent in the way people intuitively understand it, that the existence of a signature, regardless of the circumstances under which it was obtained, creates an enforceable obligation. Tompkins' argument suggested something different, that consent obtained under duress or coercion is not consent at all, and therefore the entire foundation of the agreement crumbles. These are not technical disagreements. They are disagreements about what it means to have made a choice. The judgment on these questions did not come quickly. April arrived, with no resolution. May saw procedural conferences scheduled and then rescheduled. Jackson's legal team filed their own motions, seeking to knock out Tompkins' affirmative defenses, the arguments she planned to make at trial. A newly filed court calendar moved oral arguments from January 12, 2027 to September 22, 2026 at 11 a.m. by Manhattan. Justice Reed would consider G-Unit Book's effort to dismiss Tompkins' defenses and counterclaims in an expedited hearing scheduled for late September. What made this acceleration significant was that it suggested momentum toward resolution, but not necessarily toward clarity. The judge wasn't deciding the case that day. Sometimes, in litigation, winning the procedural battles determines the outcome before any jury or judge ever hears the core dispute. The case also existed in a peculiar cultural moment. By 2026, life rights agreements had become common in entertainment, but so had public reckoning with how they were obtained. She was speaking into a landscape where narratives of coercion and abuse, once whispered off record, were now being heard and crucially documented. The same social media platform that violated the original contract, Instagram, was also the medium through which her allegations against 50 Cent were amplifying. 50 Cent himself had been focused elsewhere for much of this period. The description of Tompkins' video said she shares the untold truth of how she helped to build the G-Unit legacy, and asserted that Curtis 50 Cent Jackson wouldn't be who he is today without her. This claim that behind every successful man is a woman whose story has been erased. But control, once relinquished, is difficult to reclaim. The contract had purchased silence, but silence is not the same as agreement or acceptance. It is simply the absence of speech. When speech finally returns, the original bargain collapses instantly. No amount of legal language can prevent someone from eventually telling the truth as they understand it. What remained uncertain as September 2026 approached was not whether Tompkins had breached the agreement that seemed almost admitted given her public postings. The uncertainty was whether the agreement itself had ever been legitimate, and whether a judge in Manhattan, reviewing evidence of coercion and intimidation, would agree that it had not. The dollar amount, The $1 million G-Unit books was demanding mattered less than what the ruling would establish. If the judge sided with Jackson, it would signal that financial advantage, institutional power, and contractual language can indeed control the narrative of a person's own life, perpetually, even decades later. If the judge sided with Tompkins, it would suggest that coerced contracts carry within and the seeds of their own dissolution, and that no amount of legal precision can overcome the fundamental fact of how they came to be. The hearing was scheduled for late morning in Manhattan. Neither party had suggested it would be quick. The complexity of the case lay partly in what both sides agreed on and what they did not. Neither disputed that the contract existed. Neither disputed that Tompkins had posted videos that seemed to violate its terms. The disagreement was not about facts in the traditional sense. It was about context, and whether context matters when law is being applied. Jackson's team maintained that agreements are agreements, and that the emotional or coercive circumstances under which they were signed are separate questions that might matter for contract formation in certain narrow circumstances, but not when decades of compliance precede a sudden breach. Tompkins' team argued that the entire premise was flawed. If you signed under duress, you never actually agreed to anything. There is no decades of compliance. There is only the ongoing pressure of a contract that should never have existed. This distinction, technical as it might sound, had real consequences. If Jackson prevailed on the procedural motions in September, Tompkins would lose her ability to argue duress as a defense. The trial, if it happened, would proceed on assumptions that favored Jackson. If she prevailed, the case would likely proceed to full litigation, where a jury would hear testimony about the circumstances of the signing, including the alleged assault in the Violator Management Office. The public positioning of the case had become interesting in ways that transcended the legal documents. Jackson had become known, among other things, for his fierce protection of his image. The Power television franchise was built partly on his vision, his signature, to allow someone he had once loved and then abandoned to tell her story without permission seemed, to him, unacceptable. It was not about money.